15 minutes, each of you do, and you may reserve up to 5 minutes as the appellant, just let me know. And for the record, it's Jarelle, is it, how do you pronounce your last name?
I believe it's Guice.
Guice, is it? Okay. Soon if I would have said that it is Goss or something, I don't know. Thank you. We're ready to listen.
Okay, thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal. And my name is, again, Stephen B. Handel. I represent the appellant, Jarelle Guice, in this matter.
Okay.
I don't know exactly where to begin because there's such a chock full of issues in this case, but I think the overall point I'll start with is that night on June 3rd, 2012, when Mr. Guice wanted to die, and so his plan was to commit suicide by cop. And rather tragic and unfortunate, but that doesn't automatically equate to him having any intent to kill any of the officers, or as far as obstructing official business that would underlie the aggravated burglary. I think this is a classic case of overcharge. I mean, police officers are not your average victims. I mean, they have clout. They have a lot more clout and influence than most criminal victims, and so I think this case turned into a matter where they wanted a pound of flesh. And I think, unfortunately, yes, he did commit felonious and violent conduct that night, but not to the level to which he was charged and convicted. And so I think this appeal, what this court needs to do is bring some sense back into the matter, set the emotion aside, and bring the convictions down to the appropriate level based on what he actually did that night. First, there was no evidence in the record that he had the intent to kill any of the police officers that night. And so that would take out the attempted aggravated murder as well as the attempted murder on Officer Erkey, which Mr. Guice did commit felonious assault on by shooting into the pavement, in which the bullet skipped off the ground and struck Officer Erkey's car, his police cruiser. But if based on the video that was presented in the trial, if Mr. Guice in fact wanted to kill Officer Erkey, he had plenty of opportunity right there because Officer Erkey was well within his line of sight. He could have just pointed the gun right at him and fired right at him, but he didn't. He shot it toward the ground to try to get Officer Erkey to go away because Mr. Guice's primary focus was his estranged girlfriend, Shantasia Edwards, and he wanted to confront her and wanted to let her know what a bad girlfriend she was, whatever, and that how she made him distraught. He wanted to have that drama moment with her, and that was his primary focus that night, and also potentially to kill himself in front of her. And so he hadn't hit the cops, were not his focus. He was not trying to kill any police officers, and like I said, he could have shot right at the officer if he wanted to. And then during the standoff, there's conflicting testimony as to whether did he fire at the group of 4 officers before a hail of gunfire hit Mr. Guice 6 times. And there was no physical evidence in this scientific evidence or forensic evidence, ballistics, what have you, that would prove that Mr. Guice fired his gun. They never found a shell casing. He had a semi-automatic pistol, and with a semi-automatic, that casing ejects from the gun, and he was in a flower bed mulch. They searched that flower bed mulch backwards and forwards and found nothing. There was no shell, and it's in every interest for the police to find that shell because that would justify their shooting him and relieve of any potential civil liability in that regard. So it's in every bit of their interest to find that shell. They didn't. And the only thing they could point to was that they said, well, there's a hole in another apartment building, at the 1660 apartment building, but they conducted no ballistics, no forensic examination whatsoever to determine where that hole came from, if it in fact came from a bullet at all. So, given that, eyewitness testimony can sometimes be inherently unreliable in the sense, especially in a stressful situation, there's conflicting testimony among the officers as to whether he fired or not. Some officers saw a muzzle flash, say they saw a muzzle flash, others said they didn't see one. There was a resident in the apartment complex who filmed Angel Cardona, who had his own home video, and there's no muzzle flash in that video. So I think there are some issues here that the state's evidence of Mr. Guice firing at the 4 officers, I believe, falls short and is insufficient. And that would make a difference as to attempted aggravated murder and felonious assault as to those 4 officers. And really the most serious conduct that he committed was the felony assault of Officer Erkey, which we concede. But there was no intent to kill Officer Erkey. As far as the aggravated burglary count, the state says that the...
Excuse me, before
sorry.
I get to the aggravated burglary count, your brief acknowledges the standard by which we consider sufficiency charge.
Correct.
And that we construe the evidence in the light most favorable to the state.
Sure.
So where you have officers who indicate that they, even though there is conflicting evidence, there are officers that said they saw the muzzle flash. And your argument notwithstanding about what your client wanted to do, that he didn't have a beef with the officers, that he wanted a drama moment. He said that he was going to kill a cop that night.
That didn't come until after he repeatedly said, come on, he repeatedly begging the police officers, shoot me, come on. You got a gun, you got a dog, are you gonna kill me? Come on, do it.
Yeah, I understand that,
And he
and
kept begging them.
that's sort of an argument for the jury, and probably it was made to the jury. But the legal argument to the court is whether or not there is sufficient evidence.
Sure.
Once you construe the testimony most favorably to the state.
And I think even when you do construe most favorable to the state, and we're talking about the state's evidence here,
Right.
it was in their evidence that where he said all repeatedly, come on, kill me, just shoot me. And before he finally says, okay, I'm gonna kill a cop tonight, I think even when you construe the most favorable to the state, he only says that to induce them to shoot him, to accomplish his mission to commit suicide by cop. And so I think even when you construe that statement most favorable to the state, I think it can only be construed to the extent, given the overall context, that he only said that just to get them to shoot him. He wasn't. If he really wanted to shoot the police officers, he had plenty of opportunity to do that, and he didn't. And I think that also, it just raises. I think there's insufficient evidence as to his intent in that regard. And certainly as to, getting to the question about sufficiency, I mean, I can see sufficiency as to the felony assault on the 4 officers. I mean, I make an argument about manifest weight later on in the brief, but their testimony saying that he fired at them would definitely be sufficient for a felony assault because the standard is knowingly. But with attempted aggravated murder, the standard is purpose. I mean, that's the culpable mental state, and I don't think the state's evidence, sufficiently proves that he had the intent to kill any police officers that night. And the other aspect about the attempted aggravated murder, the indictment does not specify that the victims were police officers. They referenced the part about prior calculation and design. So the state's got to be held to that standard, and there's no evidence of any prior calculation and design. And I cited some case law that talked about that even an instantaneous deliberation is not sufficient for prior calculation and design. So, the state chose to indict the way they indicted it, and so they got to be held to it. So there's several different ways which the attempted aggravated murder should be reversed, and I think it should be taken out completely, because I don't think the record is sufficient that he had any purpose to kill any police officers that night. And certainly his conduct was knowing, and that's where the felony assault on Officer Erkey was firing into the ground, where the bullets skipped to hit Officer Erkey's vehicle. We can see the felony assault on that part, but again, there's no intent to kill. And
Could you address briefly, I don't know how much time you have, the issue of the jury forms? You indicated that they were improper, but specifically, if you could talk about the impact of your client stipulating.
well, I'm arguing plain error on that regard, and I've also thrown in an ineffective assistance of counsel as well as a backup argument that State versus Pelfrey makes very clear that the jury verdict form has to contain the, specific elements to make it effective for the degree of the offense that it seeks to convict. And whether the enhancing element or the statute or just outright state the degree. And for a felonious assault to be a first-degree felony, a felonious assault on a police officer, then the verdict form has to state that the felonious assault was committed on a police officer. And it did not say that, so it has to default to the lowest possible degree, which would be a second-degree felony. Now, all this could potentially be academic if the court rejects my assignments of error on the attempted murder and the aggravated murder, but if those are sustained, then this will matter because it'll then affect his punishment, upon remand of trial court. And I also want to touch on the point too that as far as what the purpose.
You are in your rebuttal time now.
Oh.
It's up to you whether you want to say it.
Well, I'll say for rebuttal.
Okay, thank you.
Thank you.
May it please the court, my name is Natasha Guerrero, and I represent the appellee of the state of Ohio in this matter. With regard to the intent portion that Mr. Guice is arguing that the state did not prove, there is a case out of the 9th District Outlaw which states that specific intent to kill may be reasonably inferred from firing an inherently dangerous instrument at another human being. And that's what we do have here. We have Mr. Guice, who, in the first part with regard to Officer Erke, was attempting to flee because Officer Erke was actually pursuing his vehicle, attempting to make a stop based upon a report that was made the previous day with his girlfriend at the time. And Mr. Guice fled upon seeing the officer following him, and ultimately ended up at East 29th Street. Mr. Guice ran his vehicle into a building there, actually next to where his girlfriend was staying, and exited the vehicle. Officer Erke then got out of his vehicle, was assessing the situation, saw a figure who we later was able to identify as Mr. Guice shoot. He did indicate that he saw at least 2 to 3 muzzle flashes and heard 3 gunshots. And he ducked into his cruiser for some protection. And actually there was some physical evidence there in that his cruiser had 3 bullet holes contained in it. So I don't know that Mr. Guice's aim was all that off, and that he shot at the cruiser where Officer Erke was actually trying to take cover in.
I was a little confused because the briefs are a little bit different in how they paint that evidence. Was there some testimony about the shots, the 3 shots that were fired at that point being fired directly into the ground and then bouncing off into the police cruiser? Was there testimony about bullet direction or is it rather vague?
I can't off the top of my head remember if it was testimony that it was into the ground or anything like that. I know that they did process the vehicle, and I don't know if they did the trajectory rods when they did that. I know that it was just that there were shots with 3 points of impact on the bumper, 6 inches from the top of the fender and 3 inches from the bottom of the vehicle on the driver's side passenger door. So I know that information was contained in there, and I believe there was the cruiser video was also included into evidence as well. And with regard to the standoff portion of it and Mr. Guice shooting at the 4 officers, there we obviously had the same thing of him firing an inherently dangerous weapon at these 4 officers. And he did indicate prior to that he was going to kill a cop tonight. It was once Officer Payne actually broke cover that Mr. Guice shot in the direction. He was actually, during the course of that, it was at least a 10-minute standoff type situation in which the police were engaging Mr. Guice, telling him to drop his weapon, he refused. He was getting increasingly agitated throughout that process. He did in fact shoot at the officers. 4 of the officers, Payne, Bonkowski, Fordyce, and Lieutenant Palmer, all testified to seeing the muzzle flash coming from Mr. Guice's gun. Officer Libby testified to hearing a pop consistent with a gunshot that came from the direction of Mr. Guice, and also Sergeant Rivera also testified that the initial shot did come from Mr. Guice, and it was only after that initial shot that the officers returned fire. So the state would submit there was definitely sufficient evidence to support Mr. Guice's intent to attempt to kill these officers that evening. With regard to the prior calculation and design and the 4 officers being shot in the Little Alcove area, or the area in the middle of these apartment buildings, if there was a point in the cruiser video slash body cam type body mic that one of the officers had, where it actually appeared that Mr. Guice, prior to actually moving over to the area where the shot took place, indicate that he wanted to shoot someone. And from there, obviously there was that progression between the officers and Mr. Guice, and Mr. Guice also ultimately said that he wanted to kill a cop tonight. And this was over, obviously, a course of time prior to him actually shooting at the officers in that area. So the state would submit there was definitely obviously sufficient time for him to think about what was going on, what his plan was, what he was going to do, and he took the opportunity to do so when he saw Officer Payne actually break cover from where he was that evening with the other 3 officers.
What's your understanding of what happened at the trial court with respect to the testimony regarding the bullet hole in the other building? I understand some of the physical evidence regarding that was excluded, but that there's an argument that there was testimony which should have been stricken as well.
There was some testimony with regard to, yes, a hole in building 1660, which was the building that was actually behind the 4 officers that Mr. Guice shot. There was some testimony with regard to a belief that it could be a bullet hole, and there was testimony on cross-examination that they did not go in and, pull and try to look for the bullet hole in that building or anything like that. But the state would submit that that testimony was it was a part of the entire scene there that the state was trying to paint for the jury to provide all the information as to what was going on in that area, the evidence that they found, and ultimately for the jury to make a final determination with regard to the evidence there. And that the trial court did not abuse its discretion in allowing that testimony with regards to the bullet hole in building 1660.
Well, are we going to, on the discussion, or not the discussion, but the testimony surrounding the bullet hole to support the state's effort to have admitted the photograph of the bullet hole? In other words, when you're seeking to have a photograph admitted, you have to lay the foundation, demonstrate how this is relevant. So there's testimony, we're going to find that testimony surrounding the exhibit, and then presumably the argument before the court, and then the ruling that, no, the exhibit is not coming in.
I don't remember if the actual photograph was admitted or not. I can't recall
if it that it was not.
And I believe there was, I can't remember the exact, argument that was made at that point, but there was obviously some argument made on the record with regard to the bullet hole and the pictures and all of that not being admitted with regard to that particular building. And with regard to the aggravated burglary, The jury was specifically instructed that the crime that Guice was attempting to commit when entering Miss Bracey's apartment was obstructing official business. And it actually was within right prior to Mr. Guice entering Miss Bracey's apartment without her permission, that was just after Officer Eric was actually following him and attempting to make a stop of his vehicle and him fleeing. So the state would argue that it was, in fact, there was sufficient evidence of obstruction of official business because that was all in a line of events that took place in which Mr. Guice was attempting to flee Officer Eric and stop him from obviously being apprehended at that point in time. With regard to the jury verdict forms, the state would submit that was any error that Mr. Guice is now alleging is invited error, because there was information or a statement on the record by the defense counsel stipulating to the fact that all 5 of the individuals were in fact police officers, and therefore, based upon that stipulation, the trial court instructed the jury that these 5 individuals were in fact police officers, and therefore no additional findings would have to be made. So that the state would argue that that is something that Mr. Guice ultimately stipulated to and invited and cannot now argue that as error. And furthermore, that this particular case is similar to one out of the 8th District, State versus Kilbane, in which the 8th District found that there was no plain error, where the jury verdict forms did not state that it was a felony level DUI that the jury was considering.
Well, counsel for the defense says that, if I understand his argument, that the state was tied to the issue of prior calculation and design, but the indictment indicated that, not that these were peace officers.
And my understanding is actually the peace officers' argument is in relation to the felonious assaults and the assaults, and not actually the attempted aggravated murders. So it's the, not sufficient evidence on the attempted aggravated murder, and also there's issue with the felonious assault if that gets reversed. So that was in relation to that particular portion. And also with regard to the Kilbane case, that was a case in which the evidence on the record was that the defense did acknowledge the fact that he had prior felony violations of the DUI statute, that they stipulated to that fact, and the jury was expressly instructed as to the felony nature of the DUI. Therefore, because it did not state felony in the verdict forms, was not plain error. It's really analogous to the situation we have here, in that Mr. Guice stipulated to the fact that these were police officers. The jury was instructed as such. Therefore, there was no plain error in not containing that additional finding by the jury, because they were instructed that that was not necessary at this point. The manifest weight argument is pretty similar to obviously the sufficiency argument, in that there was ample evidence to show that Mr. Guice had the intent to purposely had the intent to cause the death of these officers, and that there was sufficient evidence, and the manifest weight of the evidence supported the fact that he had prior calculation and design when shooting at the 4 officers in the standoff situation. And I guess lastly, just to touch on the 7th assignment of error, the court did not, in fact, circle whether or not it was 6 years or 6 months with regard to count number 5. However, the state would argue that that would be corrected easily by a non-proton entry, as the court did indicate in the sentencing during the sentencing and is contained within the record, that it was, he indicated it would be in years and not in months. So the state would request that this honorable court overrule all of Mr. Guice's assignments of error, obviously with the exception of the last, and uphold his conviction and sentence in this matter.
Thank you, counsel.
Thank you, Your Honors.
We have about 4.5 minutes.
A couple points I want to touch on about the shooting incident with Officer Erkey. I don't know if this court's had the opportunity yet to watch the video from Officer Erkey's dash cam, but when you watch it, you'll clearly see the puffs of smoke that come from the ground, upon him firing. So he's holding the gun, he's just firing sort of indiscriminately at the ground in Erkey's general direction. But, and there's plenty of opportunity for Mr. Guice to, if he really wanted to kill Officer Erkey, he could have pointed right at him and done that, but he didn't. He just sort of fired at the ground. But as soon as he fired at the ground 3 times, Mr. Guice takes off and runs. And you'll see that in the video because, again, he's more concerned about confronting his estranged girlfriend, and he just wanted Officer Erkey to just go away. And so he figured that, just by firing at the ground a couple times, and that'll make him go away. And at least 2 of the bullets did ricochet off the ground into Officer Erkey's cruiser, and thankfully he was not hurt. And had one of the bullets had ricocheted and killed him, it would have been a felony murder, not the regular murder, for lack of a better term, with the purpose. Because felony murder does not require purpose or intent to kill. That's just felony murder is based on knowing conduct, knowingly committing a violent offense that leads to the death of somebody. But Mr. Guice was charged with the intent to kill, and that simply just was not the case. And so, like I said, even if he had succeeded in killing Officer Erkey, it would have been a felony murder under the knowing conduct, not with the intent to kill.
Counsel, did anyone at trial testify that this bullet ricocheted? Did
Yes,
Officer Erkey testify that it was shot into the ground?
I can't recall if in regard to what he said. I know there was officer testimony as to those who investigated the scene afterward. They did take pictures. They did find, skips in the ground, if you will, for lack of a better word.
Sure.
And also too, where his car got struck, the front bumper was struck, and also the beam on the driver's side door, the beam between the door and the windshield, that was struck as well. So, and given the trajectory of the bullets and what they found on the ground and what you see in the video with the puffs of smoke, that come from the ground, every bit indicates that he fired at the ground. At least 2 bullets had ricocheted up and hit Officer Erkey's car. And again, he definitely could have been harmed in a big way. I mean, I don't want in any way, downplay that at all, and that's why, I can see the felonious assault because it was knowing conduct by Mr. Guice in that regard, but had it resulted in Officer Erkey's death, it would have been a felony murder, not a murder with the purpose to cause death. And as in reference to the bullet hole, the photograph was not admitted into evidence. The trial court allowed testimony about the bullet hole, and the photo was shown to the officer testifying about the bullet hole. And if it even was a bullet hole, I mean, they never did any. It could have been a hole from anything. Quite honestly, they never did any forensic or scientific evaluation to determine if it was a bullet hole. But the photo was shown, but at the end, at the close of the state's case, the photo was not admitted. And so, but I still say that testimony was enough to sway the jury. Once they hear, oh, there's a bullet hole in the direction of where the 4 officers were camped out at, it's not hard for them to conclude that Mr. Guice had fired in that general direction, even though no shell was found in his vicinity and no bullet was found. And I think that as a result of the fact there's no shell, there's no bullet, that testimony was substantially more prejudicial and probative, and I think that was enough to sway the jury in a big way, and I think that the court needs to sustain the assignment of error, and remand for a new trial as that whole relates to the counts at hand. So I'm just asking for the court to reverse and remand. I know there's a lot, but this case, the charges, the convictions need to be reduced at a more appropriate level based on what actually occurred and not all the emotions that are stirred up.
Thank you,
Thank
counsel.
you.
Thank you both for your presentations and for bearing with the court as to our interruption, and hopefully everybody's safe with all that. The court will take the matter under advisement, issue a written opinion which will be sent to both sides as well as released electronically. Thank you again.
Thank you.
Thank you.